in Masters of Education 571. This is the short video for week number 2. We'll be talking about tenure and collective bargaining. First, let me point out there are a number of additional readings for this week on your syllabus in addition to chapters 3 and 4, including some state statutes regarding tenure and collective bargaining. I've also included 2 sample collective bargaining agreements, one from Seattle Public Schools, another one from Linden Educational Association, and some other information. Let me quickly summarize what these 2 chapters address. First is the issue of tenure. What is tenure? Tenure is a contractual and or a property and liberty interest. I say that if you're in a public school, again, you have constitutional rights, and among them is the right to be free from deprivation of property or liberty interests without due process of law. So in a public school, you have, in addition to any contractual tenure rights, you have property and liberty interests at stake. In private schools, you would have primarily only a contractual protection. Now, tenure does not guarantee a specific position. It generally districts can reassign people to different duties. It can be acquired either expressly via the contract or via statute after a probationary period, or what's referred to as a professional service period, which is typically 3 years or less, or it can be acquired through default or what's called de facto tenure. That's discussed in your book in the Sinderman case. Now, tenure, understand, is not an unconditional job guarantee. It does, however, provide significant safeguards preventing teachers from being fired without just cause or without due process. Generally, hiring and firing is done by local school districts. It can be lost if there's just or sufficient cause, which is generally falls under 4 categories: neglect of duty, insubordination, immorality, or incompetence. Tenure can also be lost for economic reasons, in forces where a school district decides to eliminate a program or whatever. The due process you would be entitled to is typically embodied in the collective bargaining agreement, but also state law has some protections, as well as common law. You'll note that your chapters 3 refers to a case called the Loudermill case. Make sure you're aware of what that case is about, and because there's a Loudermill hearing, which is a pre-termination hearing. A number of issues come up in tenure.
For example, can a teacher be disciplined for off-duty conduct? What about criminal acts, etc.? Generally, there has to be a nexus between the act and the duties, but the cases are pretty diverse. As I indicated, I've included 2 collective bargaining agreements. There are some standard provisions, optional ones. I've asked you as assignments is to compare the 2 agreements I've provided. Let me briefly address collective bargaining. We're in an agency shop state. Generally, you have to join the union, and typically it's the WEA, although Linden Education Association is a separate entity. You have to pay or have dues deducted from your pay. The Supreme Court has said teachers have a right to collective bargaining. Some of the issues that remain outstanding are whether teachers have the right to strike, and I've included a Attorney General's opinion on that in your reading for this week. And the other questions are, can teachers be required to support union political activities with their dues? I'd ask you to think about those, and we'll hopefully discuss those in class. And that's the highlights for Education Law Week number 2.